Thanks for joining this episode of the Number 86 Lecture Series, where we discuss basic principles and applications of tort law along with landmark cases. Today's episode features Gregory Dolin, who is a professor of law at the University of Baltimore, where he teaches torts, contracts, property, intellectual property, federal courts, and constitutional law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Professor Dolin, thank you for joining us today. Let's start with some historical context. How did product liability develop as a legal concept, and why is it relatively new?
So product liability is a fairly new concept, although not entirely. And it's a fairly new concept because the economy we live in is fairly new. What was the economy like in 18th century, in 17th century? Odds are you probably never lived in the city you were born in. Odds are you probably shopped for your bread and your horseshoes and your whatever in the same shop that your parents shopped in, right? And odds are that the stuff that you bought were manufactured also locally. So there was no long supply chain. And so there was no necessarily thought given this idea of what happens when somebody manufactures, sells it to a first middleman, second middleman, etc., and eventually gets into the hands of the consumer. Somewhere along those lines, something went awry. Who should consumer be able to sue? Right? It's only with the modern economy that developed, we needed to come up with a theory as to how to deal with that problem. And product liability is, in some sense, an answer to that problem. It is both an answer kind of to the efficiency problem, but also in terms of kind of economic justice.
Can you walk us through a classic product liability case that illustrates these principles?
So one theory underlying product liability is that it's simply cheaper for Coca-Cola, like one of the kind of classic cases, I forget the first part of the name, but it's V Coca-Cola, came out from California, where a person basically grabs a Coca-Cola bottle, it explodes in their hand and severely cuts the hand, and so a suit is brought against Coca-Cola. And a company says, it was fine when it left our factory. How do you know it didn't get damaged somewhere in between by the truck driver that banged it against the wall, and maybe that's why it cracked formed, maybe that's why it exploded. And the California Supreme Court says, look, we have an injured party here. They will never know where in that stream of commerce the bottle got damaged. So what are our options? And ultimately, most of the time the question in torts is really, it's just one question. Who ought to pay for that delta between how the world looked this morning and how it looks in this afternoon after the accident? That's it. It's a question of who ought to pay. And the Supreme Court of California says, look, we can stick this waitress who picked up this bottle and whose hand has exploded with the entirety of the bill. Or, because she doesn't know whether it's a truck driver, because truck driver will say the same thing, well, how do you know it didn't left damage to Coca-Cola plant? Or we can say, look, we can impose this damage on Coca-Cola, which may be in some sense a little unfair, but they're a big company. They can spread that cost to all of the consumers. They can raise the price of their bottle by 0.01 cent across all their sales. Most consumers will not even notice it. And thus, given the fact that we never know which bottle will explode, it's just one of those chance things that happens. Sometimes you'll get a great bottle, sometimes you won't. Overall, across kind of in the long run, it will work out, right? So each consumer will pay just a little bit more for the fact that most of the time they're getting a safe bottle. That's kind of how it comes up. Claims to product liability usually come up with one form or another.
What are the different types of product liability claims that we typically see in our legal system?
Form A basically says, this is a good product. Coca-Cola bottles are generally good. But this bottle has a manufacturing defect, right? So yeah, Toyota Camry is generally, everybody knows it's a safe car, but this one had a faulty seatbelt, right? And so the product is defective. And all you have to show is, and again, product liability is essentially, it's a strict liability tort. Because Toyota can say, oh, but we did all of our inspection. We did, we behave like a reasonable car manufacturer would, but we make 1 million cars a year. Of course, by sheer chance, one of them will slip through even when you're being very careful. And the court says, yeah, that's fine. But again, who is more able to spread that cost? The Toyota or the person who gets injured? The Toyota, right? So the question is not whether they fail to do proper inspection. The only question is this car defective? So this specific product is defective. The second type of product liability claim is that the entire line is defective. So for example, you can say, look, Toyota manufactures seat belts that their clicker is very hard to release on all cars. And that creates problems because, if you're in an accident, firefighters need to extract it from a car with jaws of life, and they can't release that clicker, you have a high chance of dying because, they can't yank you out of the car. So it's not that this car has a defensive seatbelt clicker. It's that all Toyotas or all Toyota Camry specifically, right, have a particularly problematic clicker. So it's a design defect. It's not this specific product. It's the entire thing is improperly designed. The second one is somewhat more difficult to prove because if you're saying that there was a faulty design, you better be prepared to come to court and say, here's a better design. Not only is it better for the problem that I'm facing, but it's overall better. So in other words, it will not create other problems.
Can you give us an example of a case where a plaintiff alleged a design defect but faced challenges in proving it was truly defective rather than just a design choice?
In fact, there was this case, actually having to do with seatbelts. I think it was Honda being sued. And this was at the time when you had automatic seatbelts. I don't know if you remember those, but when you open the door and the kind of seatbelt will go and close it on its own. We don't no longer do them. So Honda was being sued because they had that seatbelt and their clicker was at the hip. And whereas other cars had a clicker, so if you needed to release it, it was at the shoulder. And a person got into an accident, he did need to be extracted, and because the clicker was at the hip, it was very difficult for the firefighters to reach over and get him out and yank him out in time. And if memory serves, I think he suffered severe burns because they couldn't yank him out of the car in time. So the claim was that Honda should have designed the seatbelt differently. They should have done what Toyota was doing and put the clicker not at the hip, but should have put them at the shoulder. And he said if they had it there, then the firefighters would have had a much easier job releasing me out, yanking me out, and I would not have been burned. The problem was that you can do that, and clearly it's doable because Toyota, Honda's main competitor, was doing that. The problem was that having a clicker at the shoulder created other risks. I don't quite recall what they were, but so you kind of it's 6 one way, half on the other. You're trading one solution, one problem for another problem. And the court said that's not a design defect. That's a choice, and neither one is perfect, but that's not a defect. It's not as if by putting a clicker elsewhere, you're solving your problem and not creating new ones. So if you're going to argue design defect, which again, also a strict liability thing, you don't need to say that a reasonable company would have done something different. You simply have to say that this is better, right? But you actually have to identify what's better and why is it better, as opposed to it's just you're trading one problem for another.
One case that got significant media attention was the McDonald's hot coffee case. Can you explain what actually happened there and how it's been misunderstood by the public?
So in the McDonald's case, it was heavily reported, but also heavily misreported in the media. In McDonald's case, Ms. Liebig, I believe that's how you pronounce her last name, she came to a McDonald's drive-thru window and she ordered a cup of coffee, and she received one and she put it between her thighs, I guess, as she was sort of driving away from the drive-thru window. Not the smartest decision. But apparently, 2 things happened. I think number one, the coffee lid was not, I guess, closed all the way or not tightly enough closed. And number 2, the coffee was hotter than, McDonald's was serving coffee hotter than in most other similar restaurants. And by the way, McDonald's was warned beforehand, before all of this happened, that its coffee is too hot to handle, right? That they may want to consider lowering the temperature. McDonald's chose not to. And maybe they had good reasons not to do that because coffee might taste better when it's hotter. In fact, one kind of a follow-up case came up similar to that in the UK although that I believe there was about tea, appropriately, because it was in England. The judges said, like, well, no, you have to have tea at a certain temperature, and so anything below that is simply not tea, and so no recovery at all. But in any event, as she was driving, keeping that sort of coffee cup between her legs, she's an elderly woman, so the top came off and some coffee spilled on her sweatpants. It was so hot it basically essentially melted sweatpants to her and caused her third-degree burns. And initially she just wrote a letter to McDonald seeking compensation for her hospital bills, was declined. Then she hired an attorney. They sought compensation for hospital bills and a bit of money, basically essentially to compensate the attorney. McDonald's declined that. They declined a couple of other settlements offers until it all came to trial. And at trial, the jury concluded that the two parties were at fault for those burns. One was McDonald's because the coffee was too hot and the lid was perhaps not fully closed, or maybe not sufficiently tight. And number two, Miss Liebig herself, because who puts coffee between their legs while driving? And so whatever injury was there, whatever the amount of injury, was actually reduced by the amount of fault that Ms. Liebig herself contributed to the injury. But that little point, number one, that she was willing to settle for way less, and number two, that the jury did consider her own contribution and did reduce her recovery, was almost never reported in the media. And so instead it was only kind of the top line, and the fact that McDonald's was hit with huge punitive damages was reported. And so it had particular resonance in the general public. There's no limit to human ingenuity or human imagination as to who you can sue and for what. So household appliances, cars, drinks, whatever it is, if you were injured by a product, you probably can find, on Westlaw, you can find a case showing litigation over that product. Not necessarily a successful case, but nevertheless. One way companies avoid liability is by putting warning labels, which is why sometimes you see fairly ridiculous warning labels on things. And sometimes the reason they put warning labels not just in words but also in pictures. They put those skull and bones, or they put something else, kind of some sort of picture with a red line through it, etc. But it's hard to say what product is most likely to be involved in product liability lawsuit. There are some products perhaps that are less likely to be involved, and those probably would be medical products, in part because those are tightly regulated by FDA, and you may not necessarily be able to put everything, additional warnings on the label that are not FDA approved. And so there's actually a Supreme Court case called Regal versus Medtronic, where the Supreme Court said that FDA regulation preempts a whole bunch of state tort law, because you can only go on the market based on what FDA lets you put on the market, and you can only say things about the product that FDA approves. And so you cannot, states cannot impose extra requirements. But I would be hard-pressed to think that a particular industry is more likely to be sued than another industry. As with every system, there are kind of, on the margins, there are winners and losers in the system. And obviously, the more regulation you have up front, or the higher potential liability on the back end you have, the costlier the product is going to be. Remember, the entire product liability system is premised on, or at least in part premised on, the notion that Coca-Cola will have easier time to spread the costs around. But it's still recognized that the cost exists. And so one of the effects of product liability system, and there are studies show like whether it's a great effect or a small effect, but nevertheless, small or large, it's a real effect. It does increase prices, because companies will seek essentially they want to be prepaid for any claims that they'll have to pay out later on, essentially. Again, is it worth it? Unclear, right? Does the current system create too much disincentive to innovate, to come up with new products that may be, not yet fully tested? Perhaps. But, it's not all negative. So it might have benefits that, we get safer products. So it's always a trade-off between safety versus speed, safety versus convenience. And as with many other things, as we've learned over the last years with COVID, it's always a trade-off between maximal safety and maximal convenience. And probably the answer falls somewhere in between. And depending on who you are and what your values are, you might move that needle a bit to the right or a bit to the left. Every so often you will see, again, this news story $375 million awarded for something or other, right? Or something like that. And usually when those stories appear, there's immediately a follow-on like, well, we need to do something about this crazy system. Much rarer we will see a follow-on story that's saying, the jury awarded, $375 million, but at post-trial motions, the judge reduced it tenfold to $37 million, right? Which is still, of course, a lot of money, but again, depends on the injury sustained. So certainly there are outsized awards, right? And there are, sometimes juries do go off the rails. But we do also have safeguards. We do have a motion for a new trial. We do have a motion for remittiture. Right? We do have constitutional constraints on how large a, for example, punitive damage award can be. So yes, sometimes the juries vote not with their minds, but with their hearts. And that's understandable, but that's true about every system. Sometimes the juries convict innocent people, right? Because they're just blinded by, they're disgust at the crime and the person kind of looks guilty. And that's terrible, right? And hopefully we can correct those mistakes sooner rather than later. But unless we staff juries with angels, right, they will make mistakes. And by the way, so will judges. The question is, do we need hard rules setting caps? I don't know, but just because we have set a cap doesn't actually mean that everybody will get compensated exactly what they deserve. Because again, some people may get undercompensated if their injury is actually above the cap, and some may get overcompensated because the jury might value their earning capacity or their pain and suffering more than it actually ought to. So outsized jury awards are a problem, but they're, I think, much less of a problem than media present them to be, because if you go out on the street and ask people, what do you think Supreme Court does? And they'll tell you, well, they do abortion and death penalty and, gun rights. And that's true, they do. But they also do, quote unquote, boring tax law and employment retirement plans, and they do various administrative laws, and they do patent law, things that, the proverbial person on the street neither knows nor cares about. But what does media report on? They report on the 3 cases out of the 80 that the court hears that are, the bombshell, the big cases. And same thing happens in tort law because it's sensational. And so they exist. They are a problem. I don't think they are as much of a problem as people unfamiliar with the system think they are, these outside awards. I guess I'll just close by saying also what I tell my law students is, I'll quote, I think it was Justice Scalia, that nirvana is not for this world. There is no perfect system. And, the tort system is designed to try to approximate. We can't actually restore the world to what it was like yesterday. Yesterday was yesterday, it will never be. But we try to approximate the best we can with the limited resources and limited sort of knowledge we have, the world as it existed before the accident. We will not always get it right. We will, even when we get it right, we'll still get it only approximately right. But that's kind of the nature of the law. And for all the faults, I think the system that served us for over 500 years has something to commend itself.
Thank you for listening to this episode of the Number 86 lecture series on tort law. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to number86.fedsoc.org for lectures and videos on federalism, contracts, jurisprudence, and more. Thanks for listening. See you in class.